corporate data policies, these will depend on the size of your corporation and how sophisticated it is. Some limit HR data from being transferred out. Some limit information provided for health or life insurance. Some for marital status or disability, or both. And some limit transfer of Social Security information. There is the PCI data standard. If you are subject to this and you give your data to a cloud provider that doesn't do the things that PCI requires, audits and that sort of thing, you could be liable for a ton of money. This is one you may not have thought of, but the attorney-client privilege is important if you are ever in danger of being sued or investigated by the government. The things you talk about with your lawyer are protected. Among the requirements, though, are that you take reasonable precautions with the data. If you give the data to 3 jokers who run a cloud company, I don't know that that's reasonable. Now, the final one I'll talk about is civil discovery. This is what happens when you get sued or you sue somebody. It's a period of discovery where you give over information to each other. And the federal rules require you to produce information in your possession, your control, if it's electronically stored in any medium, if it has to be translated, that's backup tapes if they're available, encrypted data that's available. The result of this is that if your data retention policies differ from your cloud provider's policies, your data may just be sitting around. So this is what a subpoena looks like if you've never seen one, if you're lucky enough never to have seen one. You zoom in. Commands you to produce all correspondence and or documents memorializing communications between you and any officer, manager, partner, member, or employee of Sucker regarding the idea you had and we stole. Sorry, we had and you stole. So on the cloud provider, have your files been deleted when you delete them? Are they sitting on a backup tape that you don't have access to? You may have to produce them. So second issue is cloud service provider agreements. These contain what you might think they contain. As Napoleon said, the best way to keep one's word is not to give it, and that's what they do. For instance, Google Docs. I just picked 2 that were easy. 4.2, you acknowledge that the form and nature of the services may change without prior notice. Sounds like they could just stop providing it. 4.3, you acknowledge that Google may stop providing the services to you without prior notice. So what happens to your data if they stop? 4.4, you acknowledge you may be prevented from accessing any files contained in your account. The idea behind cloud, one of them was you don't have to worry about IT infrastructure, you don't have to worry about backups, except that you have to worry about backups. And they're all pretty much the same. MobileMe, you might use this for your business. They reserve the right to stop the service at any time without prior notice. It's very similar, and they tell you you're responsible for backing up. The point is the cloud provider agreements tend to protect the cloud provider and not you. The third one, this is the most interesting, collateral dangers. These are the sorts of dangers that you're not really going to see or recognize until they wake you up at 7 in the morning wearing FBI windbreakers. Oscar Wilde once said, "To expect the unexpected shows a thoroughly modern intellect." He was upstaged by Donald Rumsfeld, who said there are also unknown unknowns, the things we don't know we don't know. And the poetry of Donald Rumsfeld applies to cloud computing. A third-party subpoena is a subpoena in a case where 2 parties, one is suing the other, and they want data from a third party. So they issue a subpoena. And that requires you. You may not be involved in this case at all, to produce documents that they ask for that are in your control. Now, if it's you, it's a big pain in the ass, and it's expensive. But imagine that 2 parties are suing each other, and you don't know them very well. Maybe you did business with them. Maybe you didn't. And they issue a subpoena to your cloud provider. There's no requirement that you be told about this. The provider agreements don't require it, which means that your provider may be giving up your sensitive data, and you never know. Why would he tell you? Third parties also want your data. There's nothing to prevent, very little to prevent, any third party who wants to contract with a cloud provider. Maybe they want to do searching Another company that may want to index your data is Google. They want all of your data. I imagine a conversation at Google when they first started indexing, when they said, we're going to get all the information in the world, we're going to put it all together this big search engine, and people refer to it on the news. And somebody said, wait a second, a lot of data is stored on computers, personal computers, that we don't have access to. And so he said, no problem, we'll get them to send it to us. So you'd never know what they're doing with it. You don't know who they sell it to. You know if they aggregate it and sell it, if they sell it individually. And this is a problem of control and transparency. Search warrants. A Fourth Amendment search warrant requires probable cause. That is a standard that they can usually make, but there's something called the Stored Communications Act, and there's a 2703 order, excuse me, 2703D order. The important part of that is that it requires what are called specific and articulable facts. The data is relevant or material. That's not that hard. Now, there's a prior notice requirement in the SCA. They have to tell you ahead of time if they're going to take your data, except that it can be postponed for 90 days. It's not really prior notice anymore. So this guy looks like a child pornographer. Can we just agree? He was. His name is Richard S. Goldberg. I will point out right now, I am Richard P. Goldberg. We are not related. So this guy was running around with this, doing child pornography, and he was on the run. He was on the FBI most wanted list for, I don't know, 6 years or something like that. He was captured. But imagine that he was using your cloud service provider. The FBI finds out, and they issue a search warrant. They go to every single data center, and they take everything. The problem is that, unlike certain investigations, child porn investigations involve contraband. FBI can't let these things out. They can't just say, oh, we'll just take a copy. Keep your child porn on your own. And so they will back up a truck and take everything. This could shut down your business. Something very similar happened in Texas, and I asked a friend of mine who's an assistant U.S. attorney, not in Texas, but elsewhere, I won't tell you where, and I said, look, you have this, this hypothetical, there's a child porn ring, and you find out that they are storing this stuff in this cloud service provider. That there's no way to take this stuff without shutting down not just the cloud provider's business, not their fault, right? But because we don't want them looking at our data, but also every business that uses it. And they're not going to have any notice. It's just going to shut down like that. Would you do that? Seems to me they'd have to. And my friend went to the person in charge of the district, and he asked him directly the same question, and I got a very direct answer. I'm quoting, no comment. So what do you think they're going to do? So will your cloud provider agreement to help? Let's just look at one. They're kind of long and dense. You acknowledge they may disclose your content when it's necessary to comply with a legal request or to protect the rights of the public. It may just be gone. And the problem with this is that, it's sudden. And you have no notice of it, and it just kills you. Okay, so are there any solutions? Yes and no. First, you need to demand transparency. You need to know who's running the cloud provider and what they do. Google has been contracted by Los Angeles, and if you're Los Angeles, you can negotiate these things. Smaller companies, small organizations can't yet, but cloud computing is changing, and we'll get increased transparency. Just like everything, providers will have to start taking some amount of responsibility, though there's a question about how much. If you've ever gone skiing or rented any motorized device, you know that you sign away your life. And that hasn't changed. But I think for sophisticated businesses, it will change. You also need to demand control, and these are all just subjects of negotiation. So what are the details? Remember, the goals are control and transparency. So, first, you want advance notice if your data is going to be released. If there's a subpoena, They're not instant, and so you want to know ahead of time so you can contest it.